Trials of impaired driving have become much more technical, and oftentimes what we need is an expert. There's several experts that come up routinely in impaired driving trials, such as toxicologists, drug recognition experts, in some jurisdictions, officers testifying to horizontal gaze nystagmus, collision reconstructionists. No expert is allowed to testify in any trial until they have been qualified, tendered, and accepted by the court as an expert. Many jurisdictions track the Federal Rule of Evidence, Rule 702, to give us the basis for what steps we have to go through to have an individual qualified as an expert. Rule 702 says that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify in the formative opinion if all of the following apply. Number one, testimony is based on sufficient facts or data. Number two, testimony is the product of reliable principles and methods. And number three, the witness has applied the principles and methods reliably to the facts of the case. One of the first cases dealing with experts was Fry versus United States, which was decided back in 1923 in the D.C. Circuit Court of Appeals. It had to do with expert testimony on polygraph machines. Now, of course, polygraph machines are not admissible, but the court did give us some guidance on how you get expert testimony into evidence. The Fry doctrine has to deal with general acceptance in the scientific community. In 1993, the next big case came out relating to expert testimony, and it was Daubert versus Merrill Dow Pharmaceuticals. It was decided in the Supreme Court, 1993. It was a battle of experts dealing with whether or not the drug bendictin that was being given to pregnant women to control nausea was causing birth defects. And in this case, the Supreme Court came up with several important points and rules of guidance for us. Number one, that the Fry case is superseded by the Federal Rules of Evidence, in particular Rule 702, that had been promulgated in 1993. Number two is that general acceptance is not required, but it's an important consideration. The third was that the judge determines relevance and reliability. And the fourth point was evidentiary reliability is based on scientific reliability. It was expanded, the Daubert case was expanded in 1999 in the Kumho-Tyer versus Carmichael case, where the Supreme Court again gave us some additional guidance. First, they said that the basic gatekeeping obligation applies to all expert testimony, that judges control whether or not expert testimony is admissible or not. It went on to say that the factors in the Daubert case are not exclusive and that the court should apply them with flexibility. They're guidelines, they're not hard, fast rules. The factors in the Daubert case are that the witness must be qualified by knowledge, education, experience, or training. Second factor is that the testimony has to be relevant. It's got to assist the trier of fact to determine an issue in controversy. And the third factor is it must be reliable. It has to be based on sufficient facts or data. It has to be the product of reliable principles and methods. And the expert has to show that they have applied those principles and methods reliably to the facts of the case at hand. Reliability factors are the first thing that the judge has to consider. But the Supreme Court went on to give us a non-exclusive checklist. And again, these are guidelines that the court considers and guidelines that any attorney that is trying to put an expert's testimony into evidence needs to look towards. The first one is whether or not the expert's scientific technique or theory can be or has been tested. The second one is whether the technique or theory has been subject to peer review and to publication. The third is the known or potential rate of error of the technique or theory when applied. Number four is the existence and maintenance of standards and controls. Number five is whether the technique or theory has been generally accepted in the scientific community. Now again, the Supreme Court calls this a non-exclusive checklist. Judges who are trying to decide if an expert should be allowed to testify do not have to find every factor on this checklist. Again, it is guidelines for the judge when they exercise their gatekeeping function as to whether or not a person should be allowed to testify as an expert in any trial. Finally, a piece of information about general acceptance. Horizontal gaze nystagmus tests were first studied back in 1977 with additional studies, including large ones in 1981, and then again in 2002 as to the reliability of this test. Many jurisdictions require that any officer testifying about the results of a horizontal gaze nystagmus test be first qualified as an expert. When it comes to general acceptance, the HGN test has been around for decades and has been generally accepted in the scientific community.